Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information, don't forget about our blog, consumerfinancemonitor.com. We've hosted the blog since 2011, so there is a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. Please leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you obtain your podcasts. Also, please let us know if you have ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. Today's podcast episode is a repurposed webinar that we did on March 25th entitled Impact of the Election on the CFPB, Part 4. This is Part 1 of that webinar, where we will address state enforcement and private litigation, FCRA litigation, AI's impact on litigation, and retail bank litigation. Our speakers today from Ballard Spahr are Dan McKenna, Joseph Schuster, Tom Burke, and Jenny Perkins. We have a very special guest today that I would like to introduce, and it's Ira Rheingold. Ira is Executive Director and General Counsel of the National Association of Consumer Advocates, or as it's frequently known by its acronym, NACA. It's an organization dedicated to protecting consumers from unfair and deceptive business practices. However, their membership isn't composed of consumers, I don't believe. It is composed principally of lawyers who represent consumers in individual and class action litigation. At NACA, Ira has testified before both houses of Congress, various consumer finance issues, and has offered commentary before federal agencies charged with regulating the consumer finance industry. And he's helped draft amicus briefs on issues of great concern to consumers. Currently, Ira serves on the steering committee of the Transatlantic Consumer Dialogue, which I am told deals with international consumer finance. He's also chairman of the board of the Center for Responsible Lending and the Montgomery County, Maryland Consumer Protection Commission. And he's also a very active pro bono attorney for the Washington Legal Clinic for the Homeless. So a very warm welcome to you, Ira.
Thank you, Alan.
So now I'd like to turn the program over to Dan McKenna, who is the co-chair of the Consumer Financial Services Group and one of the, I should say, major litigators in our firm and has been handling consumer finance litigation for a very long period of time. So Dan, take it away.
Thank you, Alan. Before we begin, I want to echo something that you said, and that is thanking Ira for joining us. Ira, I know that you and I have very different views on many of the issues we're going to talk about today, And I'm okay with that. And I'm grateful that you're okay with that, because disagreeing in a civil way is really critical to our chosen careers. So we really appreciate your willingness to be here today. We really appreciate your willingness to discuss this stuff with us today. And with that, let's dive into those topics. I think something that Ira, you and I can agree on, and that's the simple fact that enforcement by states' attorneys general and consumer litigation are both going to increase under the new administration. But Ira, before I ask you about that, I'd like to ask Joseph Schuster, who's a partner in our Denver office, a regulatory lawyer who also does enforcement work, to just give us a brief background on that and then ask for your comments, Ira. Joseph?
Thank you, Dan. So suffice it to say that the previous CFPB was setting up states to really be prepared to step in where the CFPB was on a number of things. We are aware, in the technology space, there were some payments providers where the CFPB was working on investigations, and they brought states in on those investigations at the end. Those things are continuing. As the new CFPB started off, we saw a lot of actions happening that put a lot of things on pause. The litigation activities, and then we even saw pulling some of those things back. So there was some litigation that was filed at the end of the last administration that those lawsuits have since been dismissed with prejudice. We've been tracking all of those. Again, Tom Burke goes into some great detail on some of those on the webinar that we did titled "Everything You Need to Know About the CFPB as Things Stand Today." But the thing that I would say is that there has been a massive pullback. That's on the supervision, that's on the examination, that's on the enforcement, all of that at the CFPB. But it's not just the CFPB. We have seen this at the FDIC, at the OCC, the FTC, the Department of Education. Like, all of these different institutions are looking at this in a different way. Where their priorities have changed. We're hearing the OCC talk about that banks cannot be debanking individuals or corporations if they're conducting legal activity. That there is a desire to push forward with fintech relationships, more emerging technologies, things of that nature, that previously the CFPB was pulling back on. Now, again, I want to turn over to Ira here in a moment, but as we were looking at this, I just kind of want to say where things were right at the election. This was California and where we are with the AG, that right at the election, state AGs were starting to focus on these activities. And that's continuing to today. We are seeing New York this is an example of something that is up in DC at Union Station, DC, talking about that New York wants to hire people from DC. I've heard that there's something like 200 positions open at the New York DFS. So that transition from the CFPB to states is really happening, I would say, in two ways that states are looking at it. You have state AGs that are getting very active in this space, and then you have state banking organizations. If you're looking at New York, that would be like the New York State AG here, and then the New York Department of Financial Services. And what they're doing, they are coordinating together. That you have the New York DFS really trying to push the supervision, what they want different entities to be doing in New York. If they're unsuccessful with that, the AG is stepping in. The AG in New York, they've introduced legislation to expand. They previously had a statute that gave them the ability to look at things from a deceptive perspective. They're adding in unfairness and abusiveness to that. The abusive prong was something that the previous CFPB had pushed for. I personally don't think that that's as important as the unfairness prong relative to deception. I think it gives them a lot of authority. And keep in mind, too, that state AGs do have the authority under the Consumer Financial Protection Act to enforce federal laws as well as they can enforce their state laws. So, I'm just going to really quickly as well, the four areas I think that those states are looking at, from my perspective, like as you're looking at, we're going to get into these throughout the webinar, are, number one, that oversight that I was mentioning that some of the state banking agencies are looking at, but also AGs. Number two, specific consumer protection laws, those federal ones, as well as the state consumer protection laws. We're starting to see some of that, that states have these on the books. They are being more aggressive in how they're looking at the laws that they have. Number three, interest rate regulations. We're seeing this in a number of different ways. In Colorado, there's the opt-out of diminishing legislation, but there's a number of other states that are looking at that as well, including Oregon, Rhode Island, and others. And then, the enforcement piece, that's really the state AG. And, there's other people on this call who will get into detail with that in a lot more. But before we proceed, Ira, I'll turn it over to you, as Dan said, to kind of get your thoughts on what you're seeing in terms of the CFPB specific activity that you can provide to our listeners.
Sure. There's so much there, Joseph, that you left me. I actually wanted to say something in response to what Dan said about having civil conversation. I'm very proud to be a lawyer. I'm very happy to be here with you guys. I'm happy to debate legal technicalities of law, or just discuss how we think about the law. And I think, we've been on opposite sides, but we all believe in the rule of law. And I think what we see here today is not normal. I want you to know that we in my community, the attorneys that I have, for law firms who may feel threatened these days, we're here to back you. We're in the same community. I respect the work that you do. I respect that you all believe in the rule of law. And I think together, we are part of the same legal profession and legal community. And these discussions that we're having today, I think, are very important. And I think we need to stick together. And I just want to know that in our community, we have your back, and that we want to work with you and make sure that we're all protected, and that what's happening today is simply not normal. We are part of the same legal profession, a profession I'm very proud of. Okay, that being said, now in terms of the CFPB, but I think it's important to say that. In terms of the CFPB, again, nothing is normal. I think in another world, I was not happy when Kathy Kraninger was the head of the CFPB or Mick Mulvaney was the head of the CFPB, but it was something we can work out. Because in fact, there was a supervisory function and there was an enforcement function, however weak I might have thought it was going to be. We're in the middle of litigation right now. I'm pretty optimistic that the district court will give a decision that will get the CFPB, at least the employees, back to work, maybe even keep the money where it's supposed to be. But I have very little hope or very little doubt that the CFPB will be gutted for the next 4 years, that the work that's being done really will mostly disappear. So I'm looking at a world where the federal regulators will mostly be absent. I've had conversations with people at the OCC and the FDIC and the FTC, and I think the same applies there too. I think for the most part, the federal government will be abdicating their role as consumer protectors. Whether or not you like a light hand or you like a strong hand like I might like, I think mostly we'll have a no hand. And I think the question is, what does that mean for us in the future? And I think, as you laid out, Joseph, I think the AGs will be actively involved. And I think we in the private bar are thinking the same way. I think as soon as the election happened, we thought about how we were going to coordinate better, how we're going to think together, how we're going to plan together, how we're going to strategize together, what type of cases will be most effective, how we'll join together in different areas of law. And we're doing that. I think the urgency came after we saw what happened, the not normal behavior, the basic dissolution of an agency or the attempted dissolution of agency against the law, against congressional laws that were made by Congress. So I think while you're seeing the state AGs stepping up, and I expect they will step up in a strong way, and we all know what states will be the leaders in that. I also think that the private bar will have a big role in coordinating with those AGs and talking to those AGs and talking with each other. I think it's in many ways, it's been an impetus for us to sort of gather together and to think about a world where maybe some of this stuff in the last 4 years, we were dependent upon the CFPB to take action, or we were looking for them to take the lead on rulemaking or taking the rule on some of the cases they take. Taking the lead on some of the law that they were making or the rules that they were issuing or the cases they were taking. Well, that's not going to be the case anymore. And so for us in the consumer bar, whether it be private attorneys, legal services attorneys, or AGs, I think we sort of view ourselves as one part of the equation of enforcing those laws, because there will be an absence of federal regulation and federal enforcement over the coming years.
So Ira, we entirely agree with most everything that you said here, and thank you for responding positively back to my comments. But one thing that we certainly agree with is experientially, we are seeing a massive uptick in AG involvement and consumer litigation. We will have another webinar next month on the uptick in AG activity that I know Joseph and others will be on. But today's focus is more on the last point you made, which is that private consumer litigation piece and the private consumer almost stepping into the role of the CFPB, as you mentioned, or working with attorneys general to do that. And one thing that we see a lot of, and this litigation exploded prior to the election, but since the election has increased at a pace that I don't think anyone could have anticipated, is credit reporting litigation. And in particular, identity theft-based credit reporting litigation. Jenny Perkins is a partner in our Philadelphia office who handles a lot of consumer litigation and credit reporting litigation. Jenny, do you mind taking us through what you're seeing?
Sure. Thank you, Dan. And we should say that, we're national counsel for a lot of companies, so we're seeing this nationwide. FCRA litigation has increased since the beginning of the year, and these numbers just reflect federal complaints. So they're not including, arbitrations that are filed, state court complaints that are filed, or even cases that are removed to federal court. So in January of 2025, there were 564 federal FCRA complaints filed nationwide, federal court. In February in 2025, that number was 610. The first 2 months of 2025, clearly the claim that was winning the race was FCRA complaints. There were 1,174 complaints filed as compared to the 631 FDCPA complaints and the 403 TCPA complaints. Now, of course, these numbers coincide with the CFPB suing Experian on January 7th of 2025. That case has been stayed, the stay request was denied as of last week. And the CFPB sued Experian alleging basically two overall complaints. That Experian was conducting sham investigations that failed to properly address consumer disputes, and that Experian was improperly reinserting inaccurate information on consumer reports. Of course, this has been stayed, but the idea of what constitutes a reasonable investigation has always been seen as an issue in FCRA litigation, both private and public. And especially we have been seeing a rise in claims involving identity theft under the FCRA. Reasonable investigation, and this has been a debate for years. What constitutes a reasonable investigation when the underlying FCRA claim is a claim of identity theft? In November of 2022, the CFPB issued a circular that said furnishers must reasonably investigate all indirect disputes received from CRAs, even if such disputes do not include the entity's preferred format, preferred intake forms, or preferred documentation or forms. In sum, the CFPB was receiving a lot of complaints from consumers saying that their identity theft claims were being dismissed or ignored, both by furnishers and by CRAs, based on the type of documentation that they decided to submit. They did not submit a police report, or a lot of furnishers have their own identity theft report claim form that they like they like individuals to fill out. Here, the CFPB has said that there cannot be any obstacles placed on consumers in terms of what type of information, what type of forms that they provide to the CRAs and also to the furnishers in connection with a identity theft claim. Highlighting just 3 recent cases, all of these cases involved identity theft, FCRA claims. The first one is pretty recent from Western District of Texas. Parcel case said unequivocally, a furnisher that receives an ACDV must investigate the dispute based on its own records and its review of the documents included in the ACDV, whether or not the consumer submits documents confirming her identity. This case actually cited the CFPB circular and looked at the fact that the right hand, meaning the individuals that are investigating the direct disputes that come in directly to the furnishers, are not always in communication with those individuals that are reviewing the ACDV that come in. And the court held that and denied granting summary judgment to the defendant on the reasonable investigation issue. Rubin was another case, And again, it denied the furnisher's summary judgment motion on a negligent and willful violation of the FCRA, where the plaintiff proffered evidence of the furnisher's policy that it would not consider additional information provided by consumers to CRAs after it previously determined that the account was not fraudulent. And then finally, this case, Petova, out of the Southern District of New York, was an interesting case because the court opined that they found it unlikely that the plaintiff would be able to prove at trial that identity theft had occurred. Nonetheless, the plaintiff submitted an affidavit in response to the summary judgment motion that said that identity theft did occur. The consumer did not enter into this transaction. And despite that, the court denied summary judgment on the issue of reasonable investigation, finding that there was no evidence in the record that those that conducted the ACDV investigations even knew about the investigations that were performed in connection with the direct disputes. I think it would be interesting, Dan, to turn it over to Ira to see what he believes the standard should be and what he believes consumers should or should not have to provide in support of an identity theft dispute.
I think that makes a lot of sense. And Ira, before you answer that question, if I can add to it, no doubt there's an uptick in fraud. No doubt there's an uptick in identity theft. But we also see a very significant uptick in consumers submitting just dishonest disputes where they clearly weren't defrauded and there was no identity theft. So I'd like your take on Jenny's question, which is, what are the steps you think furnishers have to take, and how do you balance that against what is unfortunately fraud on the consumer side?
Yeah, I guess I would argue first that I don't see a lot of fraud on the consumer side, and I've heard that as an excuse for a long time in the context of not doing reasonable investigations, that it was too big a burden because we had to figure. I mean, I know there are certain people who might file investigations, and they just that for years the credit bureaus would sort of blackball those or just say, hey, this is not a reasonable person submitting that. We're not even going to look at it. I mean, I think Jenny made the point that this has been a dispute for a long time. I think there's one other point in terms of CFPB litigation I think it's really important that we should raise as well, which is their claim also talked about the unfairness of the whole thing, right? That, in fact, the result under unfairness theory, the fact that a reasonable investigation wasn't happening also fit under their unfairness jurisdiction. So I think, again, think about the what each party has. And I think from my perspective, again, this is a conversation that's been going on for more than a decade, is that we've always believed and still believe that the credit bureaus are broken, that their investigative systems are broken, that they've never done enough. I remember a few years ago when they actually were able to attach PDFs. For years, we used to argue that they had to attach PDFs to their files when they were doing an investigation. And in fact, the whole thing has shifted so that when a consumer provides information, it was always we saw that the credit bureaus were taking the side of the furnisher almost always. We think that they have to do a significant investigation, not a transfer of data numbers or just looking at the mere facts, but in fact, do an independent, reasonable investigation. And that if whatever information a consumer supplies, again, we're talking about a very sophisticated company. Now, again, we also live in a world, so I don't know what the numbers in terms of FCRA cases and who those cases were brought against, because we have a lot more credit bureaus these days than we've ever had before. A lot of entities are collecting data and serving as credit reporting agencies. So I don't know exactly what those numbers mean. But I think in terms of reasonable investigation, in terms of the burden on the parties, consumers, it's pretty hard for a consumer by themselves to submit a dispute. And I think the burden has to be on the credit bureau to do an independent investigation. That if they have other records, they need to look at it. That it's not a mere, again, we could have a whole webinar on the Fair Credit Reporting Act. But I think there is a duty to do an independent investigation and not simply rely on the information the furnisher provides them, and that whatever information the consumer provides, that needs to be looked at by the credit bureau.
So, that's something I agree with. And Jenny, I think you would too. But I'm interested, Ira, do you agree then, though, that the base of information the consumer provides does dictate the reasonableness of the investigation. In other words, if a consumer submits no documents and just says a not mine, right, that the investigation can't be as robust as it could be if there was a police report or an FTC affidavit or a driver's license.
Right. I mean, again, well, let's go back to sort of the point Jenny was making in terms of those cases that if they didn't fit the form, but in fact they provided some information, yes. Now, clearly the investigation is not going to be as robust, but in fact, there's lots of records they can look at to determine what's happening in this case. And one of the issues we see with identity theft is there's more than a few occasions when identity theft really isn't identity theft, but it's simply a mixed file. And that's a problem with the credit bureau as well. So one of the things they need to look at independently, if someone is making an identity theft claim, is it's simply a file that's been mixed up. And I'm not sure they do that as well. So certainly the level of investigation may depend in part on how much information the consumer provides, but they also have a lot of information. And it's not simply, hey, an investigation is not reasonable if the credit bureau gets a complaint, sends it to the furnisher says, nope, our information is correct, and then the credit bureau just recites what the furnisher said. There has to be more than that. Simply turning to the furnisher and saying, hey, they're disputing it, and the furnisher saying, no, they're wrong, and then the credit bureau says, okay, the furnisher told us it's wrong, we're not going to do anything about it. So I think, obviously, the amount of information provided will make a difference, but the credit bureau has a lot of information in its hands that a consumer might have as well.
It sounds like you have an objection to the e-Oscar process as a whole.
But that's, again, a conversation that we can have for another day. But yes, I think I was amused for years when the industry was excited that they figured out they can attach PDFs to the e-Oscar system. I remember that day quite well. I'm like, wow, for a great technological machinery they have, that was quite the accomplishment. It was with great fanfare it was announced.
Well, if I can, let me kick it back to Jenny to roll us out of the FCRA piece, excuse me.
Sure. So in terms of the reasonable investigation, I think that there is an agreement here as to at least some initial steps that need to be taken. Of course, there's the arguments that we see from some plaintiffs' counsel that the furnisher should have listened to call recordings and determined that it wasn't the consumer's voice, or should have looked at handwriting and determined that it wasn't the handwriting of the consumer based on an identity theft affidavit they submit or another letter. But those issues, I think, will be continued to be debated in court and at trial. The other interesting issue that we're seeing in FCRA litigation is accuracy, right? Because, step number one that the plaintiff has to prove is that the furnisher is actually reporting something that's inaccurate. There's an interesting case out of the Middle District of Alabama from about almost a year ago, Walker versus Experian Info Solutions. The furnisher here actually, and I will say the furnisher was a debt buyer, so that sometimes makes a difference in the level of investigation that needs to be performed. But the court granted summary judgment to the furnisher, finding that it was factually accurate that an account was opened in the plaintiff's name using the plaintiff's social security number and the plaintiff's date of birth. They relied on a Middle District of Florida case that was issued a few years prior. I thought it was an interesting argument and an interesting decision from the Middle District of Alabama. I have not seen it cited in any cases in the year that it's been out there. Of course, there's always the claim that we see a lot of furnishers and CRAs make in this litigation, which is, are identity theft claims really factual and cognizable under the FCRA, or is it really a legal question? Is this person responsible for the debt? Is this debt enforceable? There's an opinion out of the Southeastern District of New York that said that it is clear that identity theft claims are factual and cognizable under the FCRA, rejected the furnisher's argument that it was a legal question, and has a nice collection of cases there from a variety of courts that discusses that issue.
Yeah, and Jenny, if I can, Oh, I'm
Yes.
sorry. If I can, I know that the Second Circuit and the Third Circuit are both addressing. Second Circuit has in fact addressed the distinction between factual and legal accuracy and has found that there is no distinction. And I believe the Third Circuit is poised to do that. One of the issues that we see a lot with that legal and factual accuracy is the use of artificial intelligence for these purposes. And I know that's an issue that is close to Ira's heart. So if you don't mind, I want to transition to that issue with Ira and ask him about the use of AI in this space as it pertains to that issue and others.
When I would talk about AI is the use of financial services institutions and how they use AI and the impact it has on consumers. So I'm particularly interested, again, how credit bureaus use AI. We're actually involved in some litigation around this issue. I think, again, when we talk about, and this is about maintaining maximum possible accuracy, and what's your duty when you're scraping information, right? When you're a credit bureau and you're collecting information and then sending it out for other people to look at. And if, in fact, you're depending on AI in gathering that information and collecting information from third-party sources, which is often the case, almost always the case when it comes to credit bureaus, what protocols do you have in place? We know that AI can lead to unfair results. We know it can lead to biased results. There's been a number of pieces that have done over time that lay out protocols that companies should use to make sure that they have the information they're getting isn't garbage. And so we have deep concern when AI is used and companies are not actually following those protocols. They're not taking all the steps necessary that the information that they are collecting through the use of AI is accurate, it's complete, and it's based on fact. And so I think there's a real risk, and I expect you'll see more litigation in this area. And again, I think it fits sort of into the credit bureau's duty to maintain maximum possible accuracy in terms of the information that they collect, that if they're relying on AI to collect that information, that what we'll be looking at is whether or not they actually have a regimen, a scheme in place to make sure that the information they are collecting through AI has in fact been cleaned and looked at very closely and make sure that that information is correct. Because if you're depending on third-party information, you're scraping it and it may not be right. And what are you doing to make sure that the information you're collecting, that you don't have a human being looking at it, in fact is right?
So Ira, in a simple way, are you basically saying if you use AI, advance at your own risk, right? Like we at the plaintiffs bar are going to hold you responsible for the accuracy of that vendor information.
Yes, and I think that's absolutely right. And I think the way I would say to a financial institution is make sure that you've got everything, you have done everything possible to make sure that that AI information that you're collecting is accurate. Because if it's collecting inaccurate information, you're responsible for it. So you need to have enough protocols in place to make sure that you've minimized or eliminated inaccuracy from the records you're collecting.
Well, you're right. We could spend an entire day, or at least another webinar, talking about the Fair Credit Reporting Act. And I'm regret that Jenny didn't get to cover all of her slides because she has so much stuff to cover. And I encourage people to reach out to her specifically on these topics because of her wealth of information. But in the interest of moving on and making sure we cover all of the topics, another area that is virtually unrelated to the credit reporting space, although obviously you can see credit reporting claims there too, is the retail bank space. And we are seeing a huge uptick since the election in retail bank litigation, particularly in deposit litigation. And Tom Burke, a partner in our office in Philadelphia here, handles a lot of that litigation. So Tom, can you share with the audience what you see going on?
Absolutely. Thanks, Dan. So this is a particularly active space based in part on the activity of the plaintiffs' bar and in part based on the signaling of various regulators, including the CFPB. These claims arise as a function of any scenario where consumers are left with losses that are generally not directly attributable to the bank. It's not a case where somebody says the bank stole my money. It's a case where some third-party fraudster has absconded with the funds and they're gone. And so you're faced with a loss and where it's going to land. Now, Ira, I'm not sure what you're seeing here, but in my experience, we see consumers bringing claims under the Electronic Fund Transfer Act, certainly in cases involving wire fraud and wire transfers. The claims may arise under the Uniform Commercial Code, Article 4A, which has its own complex paradigm. The claims may be pleaded in negligence or theories of tort, which in my experience, I think are generally being kicked by courts for various reasons that we can discuss. And then also the party may allege that the bank did something in breach of contract that led to that loss. And happy to discuss any of those that you find interesting in more detail. But the key thing we're seeing is that, this fraud is happening. Banks are responsive to it, and in our view, being proactive about efforts to protect the consumers. But there are limitations on what banks can do. And these cases are all regrettable because there's finger pointing when the real criminal is gone. But we're seeing this play out in private litigation in the courts. Is that what you're seeing too?
Well, I think absolutely. I think this is unfortunately in the world we live in, it's only going to grow. I expect, again, without the CFPB there or without one piece of the federal enforcement piece, I expect more types of fraud will exist. Again, we live in a world where we're so disconnected from human interaction and people are so live on lines, and there are all sorts of ways to get at people's bank accounts. So I think, yes, I think this is an area that's going to grow. And I think it's an area that you'll see more and more private litigation in this space. And I think a lot of the stuff that I'm seeing clearly falls under EFTA. And the reason why is because EFTA sets out some responsibilities, or it sets out who's responsible when money is lost, depending on how quickly a consumer notifies a financial institution about what happened there. And again, I think a lot of the topics we're talking about are really, even the one theme that comes out here to me is that the entity may not be the initial wrongdoer, whether in the Fair Credit Reporting case where the information they've collected has been provided to them that's bad, or in this information where a third party is engaged in a crime and has cheated the consumer. Well, Congress created EFTA so to sort of balance the inequity because the consumer has such limited protection here, while EFTA does create more protections. But I think it comes down to what protocols, what things are, what are financial institutions doing to protect themselves? Building protocols, how responsive they are to consumers, how they're meeting their requirements under EFTA, or are they avoiding it? And one of the big issues, again, another case that actually NACA is litigating, is the issue of trying to contract yourself out of your EFTA obligations, right? So where the law has laid out what your responsibilities are, but then you pass the burden back onto the consumer through your agreement they're using. Now that's in the crypto space that we're seeing that a little bit in terms of that type of transaction. So again, I think it comes down to a societal discussion about who is responsible when those losses occur, the consumer or a financial institution who can bear it more, but then what are the financial institutions doing about it? Are they actually spending enough time? Are they training enough staff? Do they have systems in place that when people actually have a problem, they respond appropriately? And unfortunately, what I hear, and some of it is anecdotal and some of it is simply what we're seeing, is that consumers are not finding their financial institution responsive. That when they make a claim to get their money back, the banks are not being responsive. The financial institutions are not being responsive. They're making people go through hoops that are not required. And they're simply not returning people. They're basically violating EFTA. So we're seeing a lot of that type of cases. I think the other areas are potential areas where you might sort of tag it. But I think most people, when it comes down to bank transactions and people being defrauded, EFTA is the place that people will look to bring those cases.
Sure. I agree with your framing of that issue as one about societal expectations and who's going to bear the loss here. And the thing I consistently hear from the bank perspective is that, putting the cost on the bank is not a cost-free option for the world at large, right? It increases the cost of services that the bank provides, and ultimately those costs often just get reallocated to everybody, which is, listen, it's not a point for no consumer protection. It's a question of what are you subsidizing and how much are you paying for it? And just a case in point with respect to the kind of fraud that we're seeing, you lose your credit card and it gets stolen and somebody picks it up and make some charges on it. Clearly, those are unauthorized charges, right? But we are often seeing cases now where people are duped into online scams and they send the money thinking they're going to get back some good or service or thinking they're making a crypto investment, and they authorize the transfer. There's no question about it. And then the money is gone. And the fingers are still being pointed at the banks in that cases. The elder financial exploitation scenario, which is a little bit more nuanced, but nonetheless, you have people who might be in their 70s or 80s, and they are being approached by very persuasive scammers who purport to be government officials, and they walk into a bank and they send their money, to some other account. And there are real questions there about what the appropriate legal framework is and, what level of obligations the bank has for those transfers. And then you have also, just a last point, a gray area where somebody is called by a scammer pretending to be someone from the bank itself or from Amazon or from the government. And the person is induced to give away their login credentials. And, there's no question. They read out their name and password and they provide the prompt on their phone to allow the scammer into their account. And there's no security system in the world that would stop this from happening. So we see these play out every day in the cases that we're litigating.
I think that's fair. Nothing you said I would specifically disagree with. But I think maybe we may differ on what the burden of the financial institutions should be. I think, what does compliance look like in those cases? Do you actually have systems in place to identify common frauds? What's your red flag system? Are you seeing something that looks bad and do you flag it ahead of time? So there are places where there are common scams or there are common uses where you might be able, where a bank should identify when a scam exists. And I think that's a different case. Now, obviously a person walking to the bank and authorizing a transfer, EFTA doesn't apply, and that would be a whole different way of looking at it, or a whole different way of thinking about that type of case. But I do think that, one, banks have a lot more, financial institutions have a lot more information, that there are specific duties laid out by the law in terms of, again, who bears the cost and what your responsibilities are. And I think it's funny. We start off with the CFPB, but the thing I worry most about is that without the CFPB there, without sort of somebody supervising financial institutions, will some of those compliance things become weaker? Will banks become more careless? Will the hammer of a federal regulator actually taking a look at what they're doing lead to less compliance and more problems? And that worries me enormously. It worries me for the banks and the financial institutions who are trying to follow the law, because there'll be a lot of folks who won't. And as we've seen in previous iterations, I came of age doing this type of litigation back in the 1990s, right? And the early 2000s, where we saw the bad guys making an awful lot of money at the expense of good financial institutions. So I worry about that a lot. But I also think that financial institutions have, because they know these scams exist, because these problems exist, they need to be spending more money on compliance. And I understand that social cost. I think financial institutions are pretty safe and sound right now, and they've been pretty good about passing costs as they come along. I just think that it's their responsibility, it's their duty to try to keep their systems as safe as possible and to prevent scams wherever they do, which I think financial institutions agree with. I think it's just the level of what they're going to expend to do that. And whether or not, now that there will not be a quote unquote financial cop on the beat, they will lessen some of that compliance, which will lead to even greater problems, which again will lead to more private actions because there'll be more problems. But hopefully that won't be the case, but I fear that it will.
Well, and Ira, I can reassure you that none of our clients, and I'm sure anyone who's on the phone, anyone who's on the video who isn't our client, everyone wants to comply, right? And prefer having an easy compliance process. And oftentimes the issue, in my experience, is the overcomplication of that process by having too many voices in the room and too many folks on that. And to that end, I'm curious as to your thoughts on the attempted expansion of EFTA, particularly given your comment that when someone walks into a branch, EFTA doesn't apply. So I would certainly agree with you that in some of these situations it doesn't apply, but that hasn't been the popular argument by the plaintiffs' bar.
Well, but again, I think there's a difference between what's a wired. Again, I'm thinking generally, we had that very interesting decision, in January or February, about what actually is a wire transfer. So I forget the name of that case right now. It was the New York AG's case versus Citi, right? Where the court defined what a wire transfer was. Now, I agree with that decision wholeheartedly, right? What is a wire transfer? Is it money that's taken from an account, and is it a bank-to-bank transfer, or in this instance, the money that actually got transferred from a consumer to the financial institution, who then pulls the money and sends it off? So I thought that was a really interesting analysis in that court, and I think that's the right analysis in that instant. And I think that's a place that should be some concern. An individual coming to a bank teller and signing something and saying, "Here, send the money this way," that may not be a wire transfer, but in a lot of instances they are. And I think that's an area that's going to get litigated even further. And I expect that, again, it's a question of who's got that responsibility. And I agree. I'm sure you're giving your clients the best advice possible in terms of what that compliance is. I think, again, that's another sort of fall off from the loss of the CFPB's role here. Is you're going to have multiple entities telling you multiple different things. And you're going to have courts telling you different things. And I think that's another danger zone where, do you lead to the highest standard that's being held out there theoretically, like the second, how do you follow the second, New York, was it the Southern District of New York's decision? Or do you take a lower standard? And what advice do you give to your clients in those instances? My advice is to build systems in place to try to prevent scams wherever you can. And under EFTA, and if a consumer complains, you know what your responsibilities are. So I think it's a really interesting area, and I expect it's an area that we will see litigated and debated in the coming years for sure.
No doubt. And I'm sorry for speaking over you right then. Tom, do you have any closing thoughts on this issue before we move on?
The only point I'll make is that this question about how banks comply with the heightened security standards is a very tricky one because, for all of the screening and freezes that banks may attempt to apply in an effort to stop fraud, all of those are what they call, friction on the customer experience. And if you have 99 legitimate transactions that are delayed, and there's a question about, well, where's my money for this home closing? Or why is the crypto transfer I just put through not happening at the price point I want? Then it creates a lot of other, negative experiences. So they're grappling with that constantly.
To make sure you don't miss our future episodes, subscribe to our show on your favorite podcast platform, be it Apple Podcasts, YouTube, Spotify, or wherever you listen. Don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for our show, please email us at podcast, that's singular, at ballardspar.com. Stay tuned each Thursday for a new episode of our show. Particularly next Thursday, we will be releasing part 2 of our March 25th webinar entitled Impact of the Election on the CFPB, Part 4. And next week, in addition to Ira Rheingold, our very special guest from the National Association of Consumer Advocates, our speakers from Ballard Spar will include Dan McKenna, Joseph Schuster, Tom Burke, Jenny Perkins, and Melanie Vartabedian, and they will be focusing on solar litigation, mass arbitration, the emphasis on unfair practices, cryptocurrency, National Bank Act preemption, and the Colorado opt-out litigation under the Depository Institutions Deregulation and Monetary Control Act of 1980. Thank you for listening and have a good day.